And then I know Your Honor has indicated the clerk should testify, and we certainly understand that. The clerk filed an affidavit denying any of these allegations. And so, again, as we address the clerk's testimony, the state would have objection to some of the information I believe the defense would propose to examine her on. We believe that an inquiry should be limited to what is appropriate and relevant impeachment, but not should be just a far-ranging fishing expedition or full inquiry into a lot of subjects that have come up since the trial that we believe are not relevant to any inquiry that is before the court here now. Obviously, rules 404, 401, 402, and 403, as well as, which of course address relevance, and 403 objections, 404, which addresses other crimes or wrongs or acts, Rule 606, or excuse me, 608, which addresses inquiry into other specific acts and impeachment, and Rule 613, which talks about prior inconsistent statements. All of those rules potentially could come into play depending on the nature of the testimony and the nature of the inquiry. But there have been allegations since the trial about the book, about this wiretapping case, about investigations into alleged use of office for improper gain. But again, all those are subsequent to the trial. And so again, depending on how the testimony goes, the state would raise appropriate objections at that time to limit the inquiry to what is appropriate for what is before the court we would submit, and that is what occurred during the trial. So we would make those particular evidentiary objections as things developed. Ultimately, that would be the state's position. I know that we're trying to put as much meat on the bones as we can at this particular point in time, but I think the reality is that the court's inquiry to the jurors will really determine the nature of the inquiry that needs to proceed from there. And at that point, the state would take the positions that I've outlined here today.
You reply.
Please, Court, Your Honor. 404, I find it somewhat ironic. The state is quoting Rule 404, Your Honor. One of the exceptions to 404, I noticed to be surprising to Mr. Waters, is motive, as if he's never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book. Motive, selling books. So we believe we should be able to get into that. We should be able to ask Ms. Hill about it. If she denies it, to call that witness, that assistant, and have her testify that she was told that. I mean, why would a clerk do what we allege she did? We think is important for Your Honor in terms of credibility and context. That's number one. Number two, Your Honor, I think we've all agreed, you're going to ask the questions, whether we agree or not. And we do agree with that. The question's going to become, as we go through that process, how, if a juror says X and they've said in their interview Y, or if they've said to us Y, or didn't include it in their original affidavit, and you don't ask that question initially, how are you going to handle, or do you care, how we suggest to you a further question? Because, as Your Honor's seen this morning, the back and forth can go on for a while, and we certainly don't want that to go on with a juror. So we're going to need some guidance on that. I'm not expecting that guidance this morning. The last thing is, as these jurors are examined, I need to understand a little bit about the logistics. Are we going to do it in this courtroom? Are we going to do it in another courtroom? Is the public going to be able to hear the responses? Will there be an audio feed if we do it somewhere else? Are you going to have cameras turned? Do it in this courtroom and have cameras turned off? And we're obviously not going to refer to jurors by their names. Even though 3 of these jurors went on the Today Show, another one went on ABC. They were all in the courtroom when the judge had them brought in. They were in the courtroom, all except one of them, for the verdict. Cameras were there then. Again, I'm sensitive to their anonymity, but I don't know that any of them have any real anonymity saying that. I think it's important not only for Your Honor to hear their answers, but for the public to hear their answers. Thanks. Thank you.
With respect to the jurors first as witnesses, I will be doing the questioning of the jurors, and I will notify the parties pretty promptly what I intend to ask the jurors. The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked the jurors on two levels. One, as a predicate to what you want to do with the clerk herself in examining her. And two, as a means of further attacking the credibility of the clerk in her testimony. I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth. I will be open to receiving that if it's done promptly, because we've got a hearing coming up the 29th, and I want there to be plenty of time to revise any current ideas about who to subpoena, who to call as witnesses, and who has to do that. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her characteristics, her personality, or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury. So I am very mindful of the limited nature of it. As I say, I'm not excluding submission in advance of information that would take the questions beyond the limited questions I've initially indicated. But I will be very hesitant about any of those questions as it involves propounding those questions to the jury. As it involves questions to Ms. Hill similarly, this is not a time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am the judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary, nor do I think it's proper, to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be used. I can't imagine allowing thousands of emails to be made exhibits in this process either emails sent by her to attorneys in the case, to other court officials in the case, or to other individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical, dealings with the county, and so forth. This is a very focused inquiry about this jury and its ability to render the verdict it rendered in an impartial manner. So, I say that to tell you that when the clerk is offered, and I think the clerk is going to have to be offered as a witness, the whole allegation revolves around the contention that the clerk made contact with the jury about matters material to their verdict, that contact was improper, and that it impacted their verdict. There's a whole lot more that Mr. Harpootlian has indicated he'd like to explore that I regard as totally extraneous to the inquiry that we maintain. I'm not going to allow those questions to be asked by way of proffer and then have the clerk answer those questions and have that be the proffer, although I consider them irrelevant questions. We're not going to handle the case in that way. If I exclude a certain question from being asked, then the proffer will be whatever in writing is chosen to be offered in that regard. But I will not conduct a hearing where there's a whole side hearing in which every question desired is asked and either required to be answered or dealt with in some other way. I don't think that is an appropriate use of this very targeted hearing that I'm directed to have. I also think it makes a great deal of difference whether the questions that are being asked relate to the clerk's conduct at the time this case was tried, as opposed to other conduct at a later time or in connections with other things than the trial of this case.